Good evening. Welcome in daily UPSC editorial audio program. Maha Storm Brewing, The Times of India. Explained to Supreme Court verdict. Asymmetry and power. The Hindu. Now the full editorial. Maha Storm Brewing, The Times of India. The next drama will come from Assembly Speaker. Supreme Court's Thursday judgment has provided respite, but had it produced a safe harbor to the Eknath Shinde government in Maharashtra. One of the apex court's conclusion was that the Assembly's Speaker, BJP's Rahul Narvekar, erred in recognizing the chief whip appointed by the Shinde faction of Shiv Sena in July 2022. Consequently, he has now been asked to identify the correct whip and legislative party leader of Shiv Sena. This step is critical to the stability of the Shinde BJP government as the identify of the whip has a bearing on the pending disqualification proceedings of 16 Shinde faction MLAs. The backstory is the first lot of MLAs who rebelled against Shiv Sena President Uddhav Thackeray were sent disqualification notices by the party whip. The twists and turns that followed suspended movement on disqualification even as Nar- Narve- Narvekar was elected speaker. He then recognized the Sindhe factions whip. This Supreme Court has struck down. Therefore, he's got to choose the new Sena whip in keeping with provisions of the party constitution. As Supreme Court has said, the political party has primacy over its legislative wing. Following the split in the Sena, the Shinde faction approached the election commission to claim the party symbol. It was unsuccessful. It was successful, however, election commission's decision won't be relevant as Supreme Court observed that its decision has prospective effect and is decided according to provisions of the symbol order. Disqualification notices here are governed by the Constitution's 10th schedule and relate to the date of actions triggering a chain of events. While Narvekar has authority to make these calls, his decisions are subject to judicial review. Consequently, the pending decision on disqualification of Shiv Sena MLAs introduced a big element of uncertainty in Maharashtra's political landscape. The June 2022 Sena split continues to leave Maharashtra's politics in an unsettled state. Explained to Supreme Court verdict. Delhi government, like other state government, draws its power to make enforce laws from the constitution. Government of India fiat can't override it. In Maharashtra case, court refusal to intervene in 2022 trust vote sealed MBA's fate. No matter the May 11 judgment. Alok Prasanna Kumar, the writer, is the co-founder of the Vidhi Center for Legal Policy. In 2018, the Supreme Court clarified that the National Capital Territory of Delhi is neither a state or nor a UT. In 2023, Supreme Court was asked to decide if Delhi is more like a state or more like a UT under the constitution. In the context of in the context of control of administration, the court was asked to decide whether control of personnel would be the Delhi government or the Delhi LG. Supreme Court's Constitution Bench judgment delivered on May 11 sealed the issue. Delhi is more like a state than the UT, and therefore the Delhi government will have full control over administration, including appointment, transfer, and terms and conditions of the services of Delhi government personals. Interpreting Article 239 AA, which governs the relationship between Delhi and the Union, the court found that nothing in this article allows the LG control of the Delhi government personnel. In interpreting the article, the court relied on the concepts of federalism and representative government, two basic features of the Constitution. Supreme Court held that Delhi, like a state and unlike UTs, get its power to make and enforce laws on certain subjects from the Constitution itself. This power to make and enforce laws cannot be overridden by the Union government. Without a law passed by Parliament, authorizing such overrides. Since no such laws was passed by Parliament in the context of administration, it was held that personnel of the Delhi government would be under the control of the Delhi government. One other reason for this interpretation was given. The Delhi government is answerable to the Legislative Assembly, which is a popularly elected body. Representative government under the constitution means the bureaucracy and ministers are unanswerable to the elected body in the state they are working for. This is the way the constitution ensures accountability of public officials in a federal system like ours. Supreme Court concluded such officers are answerable to the Delhi legislature rather than the union government. The Delhi government has already implemented the judgment through this, though this might not be the last word for on the subject. As Supreme Court notes, Parliament can always make a law giving direct control of Delhi administration to the LG, but that would arise a different set of constitutional questions for a future court to address. In the second judgment delivered by the same constitution bench, the court was concerned with questions relating to federalism and representative government in a different way. The toppling of the Uddhav Thackeray-led MBA government in June 2022, relying on complaints of a faction of Shiv Sena MLAs, the then government of Maharashtra, B.S. Koshyari, has asked Thackeray to prove his majority through the trust vote in the assembly. When this requirement of a trust vote was challenged in Supreme Court last year, it was allowed to be held, but its outcome made subject to the court's final judgment. However, before the trust vote could be held, Thackeray resigned as CM, allowing Shinde to be sworn in. A number of actions leading up to the trust vote was challenged in court, beginning with the motion to remove the speaker moved by the Shinde-led factions. The speaker's recognition of the Sindhis faction whip as the official whip of the Sena, the governor's calling of the trust vote, asking Thackeray to prove his majority in the House, and the governor's invasion of Sindh to form the government after Thackeray has resigned. In several of these instances, the court found that the authorities concerned had acted in an unconstitutional manner. The speaker should have recognized the whip of the political party and not just the legislative party, which is composed only of the elected MLA of the party. The governor should have asked Thackeray to prove his majority on the floor of the House, since the Sindh faction MLAs never indicated that they had no confidence in the leader. In fact, if they had, they would have had to be disqualified by the speaker. The speaker should have decided to issue the disqualification quickly instead of keeping it pending. Crucially, the court also clarified that the Sindh faction could not claim to have split from the main Shiv Sena to avoid being disqualified under the 10th